Hi everybody, and welcome to today's webinar, Child Safe Practices for Community Legal Centres. My name is Penny Sullivan. I'm a Sector Sustainability Coordinator at CLC Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land on which we're holding this webinar today. In Brisbane, they're the Turrbal and Yagara people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role of Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. Today, we're really pleased to be joined by Karinya Kamsone at Holding Redlich, who'll be providing an overview for us of the National Child Safety Guidelines and Principles, focusing on their application to community legal centres, including issues of risk assessment, complaints handling, training and reporting. I'll let Karinya tell you a bit more about herself when I hand over in a moment. Today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints and other materials have been emailed out to everyone who registered and are available to download from our website and from the handout section of the GoToWebinar control panel. There are two ways you can ask questions. You can press the button that looks like a hand. We'll see a hand go up at our end and we can unmute you so you can ask the question via the microphone. Or the easier method and our preferred method is that you can type your question into the question box on the control panel and we'll read your question out at the end. As I said, we will hold questions until the end of the presentation, but feel free to type them in as you think of them. I'm now going to hand over to Karinya and talk to you again at the end of the session. Welcome, Karinya.
Good morning, everyone. I'm a Senior Associate working in the Workplace Relations and Safety section in Brisbane of Holding Redlich. The Brisbane team is headed up by Rachel Drew. And prior to this, I worked at CRH Law for a number of years and I was associate to Her Honour Justice Catherine Holmes when she was in the Trial Division and Court of Appeal in 2006. My legal experience is primarily in the area of employment and discrimination law. I can't boast any experience as a children's lawyer or legal work in the community sector, but I have some experience of the broader community sector, including periods of work as a DV support worker at a women's refuge and as a contracted support worker for children in crisis care for the Department of Child Safety, although that was many years ago now. Certainly through Rachel Drew's long-term work for the Queensland Teachers Union and the Independent Education Union, our workplace team is regularly engaged in matters involving child safety and wellbeing. The webinar today comes about as a result of some research I conducted for CLC's Queensland through our pro bono legal advice scheme, which was then identified as an opportunity for further training. To provide an overview of what we'll discuss today, this presentation is targeted at CLCs, but I acknowledge that some of you will come from different services or sectors, so I hope it will be helpful to you as well. It will be most applicable to organisations receiving Commonwealth funding for child-related services, but also other organisations providing services to children and those with an interest in child safety risk management. So the aim is to provide an understanding of the Commonwealth Child Safety Framework, the National Principles for Child Safe Organisations, and child safety risk assessment and risk management practices. I could add that I aim to give you an hour of your day when you won't be thinking about pandemics. But unfortunately, the health diseases analogy has been made in relation to child abuse in our society, and in fact, a public health type response encouraged, focused on preventing problems, responding quickly and minimising the impacts. So in relation to the topics we're going to cover, I'll give you a background to the national principles and the application of the Commonwealth Child Safety Framework. We'll explore, we'll touch on mandatory screening and reporting, and then get into application of the national principles through risk assessment and issues of commitment to culture, suitability assessments, complaint handling and review. The final report of the Royal Commission into Institutional Responses to Child Sexual Abuse was presented to the Governor-General in December 2017. Volumes 6 to 8 of that report deal with child-safe institutions. The most relevant of those to today's presentation is volume 6, which is entitled Making Institutions Child Safe, and looked at preventative measures which would not only address the risk of child abuse in institutional settings, but also the responsibility and opportunity of organisations to lead to change in the community with respect to child safety. The report defined a child-safe institution as follows. Child-safe institutions create cultures, adopt strategies and take action to prevent harm to children, including child sexual abuse. They consciously and systematically create conditions that reduce the likelihood of harm to children, create conditions that increase the likelihood of identifying and reporting harm, and respond appropriately to disclosures, allegations or suspicions of harm. The Child Abuse Royal Commission report outlined 10 child safety standards, which went on to inform the national principles for child safe organisations. Before we look at those principles, I thought it might be useful to understand how these principles have come to be relevant to community legal centres. Some of the as part of the federal government's response to the Child Abuse Royal Commission, a national office for child safety was established within the Department of Prime Minister and Cabinet, tasked with the development and implementation of a number of measures to address the Child Abuse Royal Commission findings. One of these measures was the establishment of the national principles, which we'll explore in more detail later in this presentation. Another measure was the implementation of what is called the Commonwealth Child Safety Framework. This framework is aimed at ensuring Commonwealth entities have adequate policies and procedures in place for the protection of children and young people. It is described as a whole of government policy that sets minimum standards for creating and embedding a child safe culture and practice in Commonwealth entities. The framework requires those entities to complete a risk assessment to identify the level of responsibility for children and the level of risk of harm or abuse, and implement appropriate strategies, train staff and monitor compliance to ensure staff are aware of and comply with the outcomes of the risk assessment and relevant legislation, including working with children checks and mandatory reporting requirements, provide an annual statement of compliance, and adopt and implement the national principles by February this year. In addition, the framework recommends that Commonwealth entities impose child safe requirements through written agreements on any individual or organisation which is funded by the Commonwealth entity to provide services to children or for activities that involve contact with children. One of the primary ways in which this is to be achieved is through funding agreements and also in the terms attached to Commonwealth procurement. According to the National Office for Child Safety, there is the potential that third parties, funded entities who refuse to comply with the framework would not be provided with any further funding or be ineligible for new grants. The first step in applying the framework to funded entities has been that Commonwealth funding bodies have written to organisations seeking confirmation of compliance with any working with children checks and mandatory reporting requirements, requesting that organisations return a statement of compliance with respect to those obligations. CLC's Queensland received correspondence of this kind from the Attorney General's Department some time ago with a template statement of compliance attached as I'll show in the next slide. That is only intended to be a template, and the statement is not required to be in those exact terms, but we'll need to address those key issues of mandatory screening and reporting. And the next step in the application of the framework will involve confirmation of risk assessment and strategies, training and implementation of the national principles for child safe organisations. In terms of mandatory screening and reporting, it's likely you'll be familiar with these requirements, but it might be useful to summarise how these apply. The relevant act is the Working with Children Risk Management and Screening Act 2000, Queensland, and the relevant agency is the Blue Card Services Agency. The notion of regulated employment underpins the Act. Regulated employment involves services that are directed at or involve children. I've extracted here the section relating to health, counselling and support services, as these are most directly relevant to CLCs. Some of the other categories include schools, childcare facilities, churches, clubs and associations involving children, private teaching or education outside of schools. It was reported in the last CLC's Queensland annual report that about 10% of member service clients were children or young people under 25 years old. In most cases, I expect CLCs do not primarily provide services to children, so this is the first basis upon which the screening requirements would not apply. There are also a number of exemptions applicable to lawyers. With support services for children, but while support services for children, including those that provide emotional support, mentoring or pastoral care, are regulated employment, if the usual functions of the employment include legal advice or legal advocacy services, this is specifically excluded from the definition of a support service under the Act and is therefore not regulated employment. However, highlighting some potential fine distinctions, the Act provides that an example of what would be regulated would be, it's at the bottom of this slide, a support service that provides emotional support for child victims or witnesses in connection with court or other legal proceedings. So the important distinction seems to be the type of work being performed. No doubt there's potential overlap, but where the primary purpose of the employment is legal advice or advocacy rather than pastoral or emotional support, it is not regulated and the screening requirements do not apply. It is only legal advice or advocacy which is exempt. Staff or volunteers who are engaged to provide another type of support service, such as counselling or emotional support for children, are potentially regulated and would need to be screened. Further, it is whether the employee is providing that particular service which is important. Therefore, administrative or management staff of a legal service are not likely to be engaged in regulated employment because they personally do not provide a support service to children. Rather, they provide administrative and management services to the organisation. However, this is highly dependent on the context. For example, in relation to administrative and other non-teaching staff in schools, given the number of children they interact with and the regular nature of this as a core part of their role, these employees would be regulated and normally do require screening. In addition to the legal advice service exemptions, Schedule 1 of the Act provides that Australian lawyers are exempt from screening requirements if working in their professional capacity. And this applies even if they are working within a service which is otherwise regulated. I would expect this scenario would be unusual, but for example, a lawyer engaged by a youth mentoring support service to provide legal advice to children would be exempt from the screening requirements. Importantly, under this Act, employment means engaged to carry out work and includes work carried out voluntarily as well as for financial reward. In summary, I've just summarised what I've said there in this slide. Lawyers providing legal services on a paid or voluntary basis are not subject to blue card requirements, but other staff or volunteers who provide a support service to children would potentially be subject to blue card screening. The amendments to the Queensland Working with Children Screening Act, which excluded lawyers and other professions from the definition of regulated employment, were introduced in 2007, with the stated purpose being that disciplinary legislation had been introduced by then applicable to these professions, which was seen to provide sufficient protection. There's also naturally the consideration of administrative burden and costs of compliance in the implementation of these laws. Following the Royal Commission, there is the potential for some of the exemptions in relation to screening requirements to be reviewed and the broadening of screening requirements in general. And there has already been some examination of inconsistencies between jurisdictions in relation to screening requirements. So this will be a space to watch in terms of compliance in future. In terms of mandatory reporting obligations, again, these are likely to be familiar, but I think it is worthwhile summarising. There are no mandatory reporting obligations imposed on employees or volunteers of legal services under Section 13E of the Child Protection Act. Only certain people are mandatory reporters, such as teachers, doctors and childcare workers. However, any person can make a voluntary report in relation to a reasonable suspicion that a child is in need of protection under the Act. There are obviously professional duties which place a limit on this, including solicitor-client confidentiality as well as legal professional privilege. The Australian Solicitors Conduct Rule provides that a solicitor may only breach the duty of confidentiality in certain circumstances, and this includes for the purpose of avoiding the probable commission of a serious criminal offence and for the purpose of preventing imminent serious physical harm to a client or another person. The focus, of course, there is future harm. So there are no mandatory reporting requirements under the Child Protection Act, but there is the possibility of voluntary reporting, depending on the context and any impact on professional duties. There are also mandatory reporting obligations under the Family Law Act for various practitioners, including family dispute resolution practitioners or arbitrators and independent child lawyers, which will no doubt be familiar to any family law practitioners listening. One of the differences in the family law jurisdiction is that the family court has the best interests of the child as a guiding principle, and therefore it follows that practitioners must also uphold that principle in terms of their overriding obligation to the court and the administration of justice. So with the exception of the mandatory reporting obligations under the Family Law Act, there are generally no mandatory reporting obligations applicable to CLCs. Just to flag some movement in this area, however, there is a consultation draft bill which is being considered by Parliament, which would potentially introduce a criminal offence for failing to report belief of an offence of a sexual nature committed against a child. This is quite problematic in terms of its impacts on those legal professional duties, obviously, and has much broader implications for people working with children. So I just flag it at this stage and won't comment on that further, but it may be something to watch in terms of the progress of that bill. So it's likely that the statement of compliance in the vast majority of cases for CLCs would say something like this: we do not provide any services to children and do not have regular interaction with children at this service. Queensland legislation does not impose any mandated police or working with children checks on the service. There are no mandatory reporting obligations that we are required to comply with in relation to suspected harm or abuse of children. And we are nevertheless committed to child safe organisation principles and have applied these where relevant to our practices and policies. However, your particular activities and services might, of course, require a different statement depending on those compliance issues. Setting aside mandatory screening and reporting, there remains the issue of compliance with the Commonwealth Child Safety Framework and application of the national principles for child safe organisations. The development of the national principles was led by the National Children's Commissioner, Megan Mitchell, and these are intended to foster a nationally consistent approach to organisational cultures that foster child safety and wellbeing. They reflect the Child Abuse Commission's 10 child safe standards, but expanded so as to include all forms of potential harm to children and young people, not just sexual abuse. The national principles were endorsed by COAG in February 2019. They form part of the Commonwealth Child Safety Framework, but are also likely to be implemented through other cooperative measures between states and territories. In addition to adopting these principles, the Commonwealth Child Safe Framework added the following overlapping requirements. Complete a risk assessment to identify the level of responsibility for children, the level of risk of harm. Train staff and monitor compliance to ensure staff are aware of and comply with the outcomes of the risk assessment and relevant legislation. Provide an annual statement of compliance, and those are the matters I touched on earlier. Moving on to risk assessment and management. Each CLC will need to make their own assessment of risk depending on the type of service provided, including the level of contact with children and young people. For some CLCs, this contact may come in the form of direct and regular legal advice provided to children. For others, the nature of this contact may be more irregular or unpredictable. In addition to legal services, staff and volunteers of CLCs may potentially have contact with children or young people when they accompany adult clients of the service, when staff provide outreach legal education services, or perhaps if they host students or young people on work experience. Circumstances in which children and young people may be alone without a parent or carer should obviously attract greater focus in this risk assessment and corresponding policy development. Types of contact with children that might need to be considered include physical or non-physical contact, known or potential contact, and telephone, written or electronic communication. Risks include incidental or accidental harm, physical abuse, psychological harm, neglect, and sexual abuse. As noted earlier, the national principles were expanded so as to encompass all forms of harm to children and young people, not just sexual abuse. Harm should be defined and understood with reference to physical, psychological, and emotional abuse or neglect, or sexual abuse or exploitation. One of the many findings of the Child Abuse Royal Commission was that one reason that abuse was overlooked and left unaddressed in some institutions was due to the lack of understanding of these concepts of harm, including the deep and potentially long-term psychological impacts of this conduct. Section 9 of the Child Protection Act in Queensland defines harm as any detrimental effect of a significant nature on the child's physical, psychological or emotional well-being. And on this slide, I've just given some examples of what should be included in any understanding of potential harm to children. In addition to the risk of physical and emotional harm to children and young people as a result of their interaction with adults including employees and volunteers at CLCs. Consideration may need to be given to any risk of harm associated with the location and physical environment of each service, including access to computers and IT services. Some measures suggested within the Commonwealth Child Safe Framework tools available through the National Child Safety Office is to address environmental and situational risk include contact with children occurs in visible work environments. Products, materials developed for children are located in open areas. Contact with children is culturally appropriate and interpreters are used if needed. Children are accompanied by a parent or guardian. Personnel are supervised where appropriate in situations where they have contact with children. I have recently had involvement in an employee conduct matter involving allegations of inappropriate dealing with a child, which is said to have occurred in an office. And an important piece of the response to the allegations has been that windows were in fact deliberately installed in that office, which allowed full view of the office from adjacent areas. So that is something which is not only protective of children, but protective of staff in terms of transparency and their interactions with children. The nature of each service's contact with children will inform the policies that are adopted, consistent with the national principles to adequately mitigate risk in relation to child safety and wellbeing. The likelihood and severity of these risks will also naturally influence the options to manage them and the level of formality desirable in policies and procedures. There are 8 mandatory risk management requirements imposed on organisations regulated under the Blue Card system in Queensland. While we've just looked at the reasons why mandatory screening would generally not apply to CLCs, the Queensland Blue Card requirements, I think, provide a useful framework for implementation of child safe risk management requirements. And you can see that they are grouped there under the banners of commitment, capability, concerns, and consistency. And there's a lot of parallels with the national principles. The first elements relate to commitment and culture. As reinforced in the Royal Commission definition of a child safe institution, this is effectively about creating a culture that adopts strategies and takes action to prevent harm to children. Importantly, as I noted in terms of one of the training videos produced by the Queensland Blue Card Services, there's an indication that people who may wish to harm children are often drawn to organisational environments where there is a dysfunctional culture and an absence of effective risk management. A number of the national principles fall under the commitment and culture banner, and I've included them in the next slide. They are: number 1, child safety and wellbeing is embedded in organisational leadership, governance and culture. Number 4, equity is upheld and diverse needs respected in policy and practice. Processes to respond to complaints and concerns are child-focused. Policies and procedures document how the organisation is safe for children and young people. For many organisations, there will already be risk management policies, service commitments, policies and codes of conduct governing your work. It may be that what is required is to simply review those policies and add child safety related commitments and standards to those documents. I expect the values of equity and respect for diversity are likely to already be reflected in CLC policies and practice. However, the specific needs of children from diverse backgrounds may need to be considered with particular reference to the services and location of each CLC. For example, special consideration might need to be given to the cultural safety of Indigenous children, including principles of self-determination and connection with family, community and culture, which are also referred to in the Queensland Child Protection Act. In terms of the development of these statements of commitment or standards, it is recommended that children and young people, as well as families and relevant communities, are consulted and encouraged to participate. The national principles require the provision of information to young people or other stakeholders about child wellbeing and safety principles, and also their involvement in policy development. This may be as simple as having a copy of the national principles or a service commitment to child safety displayed in a prominent place, accessible to young people and their families, or it could involve consulting families or young people who access services about issues of safety and child wellbeing, and providing an opportunity for them to give feedback or input into those issues. A code of conduct is, of course, a useful way of establishing standards of behaviour expected of all staff, volunteers and visitors in relation to child safety. Depending on the risk assessment undertaken and relevant circumstances, a code of conduct addressing child safety issues might address standards or expectations in relation to topics such as the delivery of services to children, the supervision of children, behaviour management, one-on-one interactions with children, communication with parents or carers, the transport of children, and IT policies. Hand in hand with the establishment of a commitment and standards is a strategy for managing risk. One of the most important components of this is appropriate policies for recruiting and selecting suitable employees and volunteers. Again, this would depend on the risk assessment undertaken in relation to likely interaction of staff and volunteers with children, but examples of what could be done in this area would be making a criminal history check, a precondition of employment, and I should say there, considering whether blue card screening is applicable, revising position descriptions and selection criteria in relation to roles which involve services to be provided to children, having interview questions or questions in terms of reference checks targeted at candidates' experience with children and any potential concerns arising from those interactions. And of course, a probationary period of employment is another way in which suitability can be assessed. Following commencement of employment, induction or training of staff and volunteers is critical. The national principles anticipate that organisations will implement specific training in relation to child safety issues for employees and volunteers. That is specifically Principle 7, staff and volunteers are equipped with the knowledge and skills and awareness to keep children and young people safe through ongoing education and training. Also, federal grant recipients will be required to show that employees and volunteers are trained about child safety risk management and complaint handling policies and procedures. The basic features of training should include introduction to the organisation's child safety commitment and risk management system, including key personnel involved in that system in the organisation, training in relation to code of conduct and key policies such as grievances and complaints procedures, training in expectations in relation to the reporting of any suspicion of harm and the handling of any disclosures, and obviously keeping a training register to confirm when and what training was provided, as well as keeping a record of any ongoing or ad hoc mentoring or coaching by supervising staff. A complaint handling policy will also be essential to responding in a timely and effective way to any disclosure or suspicion of harm, as well as any breaches of the organisation's policies. The complaints policy should set out what expectations there are in relation to any disclosures made to staff about harm or any suspicions of harm, as well as advice about how to handle those complaints or disclosures. Disclosures that involve service staff or volunteers might need to be distinguished from disclosures involving external individuals. The disclosure and complaints process should also be easy and accessible for children and young people to use and understand. In terms of the content of any complaint policy, as a guideline, I've just indicated here, there should be a clear expectation that complaints or disclosures are clearly and accurately documented. Clarity should be given about who complaints can be reported to and who in the organisation will manage or investigate complaints. A clear expectation that complaints are handled in both a timely and a thorough manner. Support made available or appropriate referrals made for the relevant child or affected staff. Outcomes should anticipate the potential for referral to police, voluntary reporting, or other immediate protections, such as the exclusion of certain individuals from the service. In relation to breaches of child safety policies by employees or volunteers, this is likely to link in with employee disciplinary processes or other grievance processes, and depending on the nature of the breach, may include further training or counselling, warnings, suspension from duty, investigation and show cause or termination processes. The national principles also require that implementation of the national child safety principles is regularly reviewed and improved. Naturally, any successful risk management and compliance procedure or policy needs to be regularly reviewed to ensure it is appropriate and adapted to the services provided by each CLC. In addition, grant recipients will be required to provide an annual compliance statement. So this would suggest that an expectation is that this review would be done at least yearly. That review might include reference to any changes in service provision, changes to clients or visitors to the service, any reported incidents, or any legislative or other policy changes affecting the service. Now, I was worried about being over time, but I think I'm doing quite well, and we may actually have a bit of time to receive questions, perhaps have a bit of a discussion. Hopefully much of this sounds like common sense and will be consistent with values already underpinning your workplaces. Lawyers and CLCs have limited mandatory screening and reporting requirements to comply with. Hopefully a lot of the child safety practices would already be in place for dedicated child-related support services, although the challenge is often formalising and documenting these practices. Where a service has no interaction with children, there may be no relevant Commonwealth funding to which the Commonwealth Child Safe Framework could attach, and therefore no new requirements to be complied with. If there is only limited services or interaction with children, the risk management could be tailored accordingly and might simply involve a statement of commitment to the national principles and perhaps some smaller amendment of existing policies related to standards of conduct and complaint handling. Overall, though, I think the notion of our shared responsibility for child safety and wellbeing is compelling, and the national principles certainly provide the opportunity for organisations to assist in leading that change. So that concludes my presentation, and it looks like we have some time now to hopefully answer some questions.
Yeah, it's thanks very much, Corinna. That was really informative, and I think it's given everyone a really fantastic summary of the key issues to consider in this space. We do have some questions that have come through, so I will read those out and then you can answer them.
Great.
So the first one is from Simone, and she says, if staff already have yellow cards, is this sufficient?
Okay. I'm actually unfamiliar with what she's referring to in terms of yellow cards.
Okay.
I'm sorry. Sorry.
We might have to come back to you on that one, Simone, and get you a bit more information about that. So we might leave that one to one side. I have a feeling it's to do with assisting vulnerable adults. But
I see. Yes. Okay, that might be why. Yep.
Yep. I might have to clarify that.
Sorry, Simone.
So the next question is from Carol, and it's, what is the situation with solicitors who deliver CLE in schools? Would they need working with children checks?
No, I think the general exemption applying to Australian lawyers would apply there. So this would be the situation where schools would otherwise be regulated employment, but because the exemption, you are providing legal advice and advocacy, and also because you're a lawyer providing services within your profession, then the exemption would apply. It would not be required.
Okay, terrific. Thank you. The next question is from Janine, who says that she missed the family law reference regarding mandatory reporting, and just to know if this is in the slides.
I'm really sorry. I only touched on the mandatory reporting very briefly in terms of the Family Law Act, and it is I'm certainly not a family lawyer, so it is not in the slides. But yeah, so I can't assist further in terms of those requirements. But as I understand it, it only relates to certain practitioners under that Act.
Okay, fantastic. So the next question comes from Janet, and she said, we work with 10 to 18-year-olds. That's our only client group. Children who are GILIC competent are entitled to confidentiality. As such, parents are not necessarily present, and having children visible in open space when meeting with our social welfare staff is problematic. This would work against the young people in our ability to work with them. So I guess that's an interesting scenario.
Yeah, look, I think, some of those issues of visibility have to be balanced with those priorities to be given to confidentiality and also privacy in some cases. Other measures you might look at is having an additional staff member potentially present. Otherwise, careful documentation as to those interactions. That's just a couple of suggestions, but I take on board that visibility is not something always that's going to be an easy or applicable type of approach.
Okay, and our final question comes from Carol once again. Do exemptions for lawyers apply to migration agents?
If I just go back to the slide in which the exemption is contained, the specific exemption is the employment is not regulated employment if the employee is an Australian lawyer who, under the Legal Profession Act, may engage in legal practice in this state, and the employment involves the employee engaging in legal practice. So it centres on that issue of whether they fall within that definition. That's certainly something that I could check. Rachel Drew does some work in the migration area, so I'd be happy to check on that for you, Carol, and confirm whether that would apply.
Okay, lovely of you. Thank you, Karina. So we have one more question that's come in about the intersection between reporting requirements and confidentiality for lawyers and legal professional privilege.
So as I've touched on there, we are bound by our duties as lawyers in terms of confidentiality. There's no mandatory reporting requirements in place in relation to lawyers. And I think that would potentially be an acknowledgement that we are bound by those duties of confidentiality and legal professional privilege. I guess I touched on the issue of voluntary reporting because there may be staff who are not bound by those same requirements. And sorry, just checking on the question there.
So it's about the intersection between reporting requirements and legal professional privilege.
I do think I touched on that generally we can't, in many cases we can't report, but that really depends on who is our client, who is that duty of confidentiality, who does it apply to. So I think it would depend on the circumstance as to whether those professional duties prevent any kind of reporting.
Okay.
Certainly there's no mandatory reporting requirements on lawyers.
Yes, okay. All right. Thank you very much. Well, that looks like the questions that we have for you, Karinya. So I think there's one more that's just come in from Janet again to say there are some issues with the CPA information sharing provisions. Who has to provide information when required by child safety, which captures CLC lawyers?
Okay. Sorry, CPA in this context?
Child protection.
Oh, okay, yes. Certainly there are mandatory requirements under the Act, I believe, which may apply to those individuals. Yes, absolutely. Yes, yes. And I didn't mention that as I was referring generally to lawyers in CLCs, but certainly if you're acting in that capacity, there are some reporting duties, as I understand it. Yes.
Yes, and as Janet rightly points out, not all lawyers just
yes, yes, yes.
Janet's with the Youth Advocacy Centre.
Okay.
So,
yep.
Okay. Hopefully that answers people's questions. Karinya's going to provide a little bit more information about the application to migration agents. So thank you so much for doing that. And we will come back to you, Simone, on the question of yellow cards as well. So we'll provide a bit more information about that. So I think in the absence of any further questions or comments, we will leave it there. And so thank you very much, Karinya, for all of the time and effort that you've put into pulling together such a comprehensive presentation. And I'm sure it's been really valuable for everybody who's been on the webinar today. That wraps up our proceedings. So the webinar will be available on the CLC Community Legal Centres Queensland website. There'll be a recording available, so hopefully you'll be able to take advantage of that.
Thank you very much, everyone. Thanks for having me.
Thanks, Karinya. Thank you.